Welcome, everybody, to our industry update this month. We're so glad you're here. I'm really excited to welcome our guest this month. Terry Williams is the Vice President of Underwriting here at Heritage Title. Just an incredible wealth of knowledge, great resource for our brokers. I was just asking him to remind me how long he's been in the title business, and 47 years is the answer to that. So just an incredible guy. And he's underwritten a lot of really interesting projects all over Colorado, but one that I'll mention that everyone's heard of is Coors Field. So back in the day, he did the underwriting for that and has done a lot of commercial underwriting over the years, as well as residential and builder and everything else out there. So we're glad you joined us. There's just always lots of great things to touch base on in the world of title. While things don't necessarily change every day, I guess in a way they kind of do, or we start to see, as we see shifts in the market, we see shifts in the different types of tools and resources we use as a title company. And we're excited to talk about some of those things with you today. So without further ado, I will turn things over to Terry, and please just pop your questions into the Q&A, and we'll be happy to answer and get to as many of your questions today as we can. So thank you, Terry, for being on, and I'll let you take it away.
Thanks, Jill. Good to be doing this again. Always look forward to this. Always enjoy it. I started in 1976 in Greeley. I was born and raised in Greeley and started the title business up there, and it's all I've ever done. And it's all been in Colorado. It's all been on the Front Range, and I love it. And Jill will tell you this: I'm a title geek, self-proclaimed title geek. I love the history of it, the history of Colorado, and how documents recorded 100 years ago still affect property today. So, and I don't really just want to sit here and talk. I really want to make this interactive. I know it's a little different over a Zoom call, but it's important that if you have questions, regardless whether it's something I'm talking about, or if you have a question on a deal or an unusual transaction, please let me know. And because I like that part of it. So we're just going to talk about some trends and some things we're seeing. We have we're still doing a lot of deals. They're challenging at times. But one thing, I'm going to share my screen here. I wanted to talk about, and let me do that real quick. Everybody see the beneficiary deed?
Not yet.
Oh, maybe I didn't do that right. Sorry. There?
No. Sometimes that can be tricky, especially when we have multiple monitors. We all have like 2 or 3 monitors at the office.
I'm going to get some help here. Oh, screw that one. Oh, you got to hit the share button. Jen is not only the vice president of sales, she's also my personal IT person. So, so you can see the beneficiary deed. Okay. And so we've had these now for quite a while. They've probably been around Colorado, maybe 12, 15 years now. And the purpose of the beneficiary deed is you can set this up that upon your...
You took it off your screen.
Oh.
Because you're sharing that screen. Nope, you have to move the beneficiary's deed over there.
Okay. Good.
And then make your window big. Perfect.
Okay, now we're there. Okay, so everybody can see the beneficiary deed now. Good. This is one that was recorded, so I'm not sharing anything that isn't actually a public record already. So the purpose of a beneficiary deed is to assist in estate work, and basically to not have to do probate. So the purpose of it is I can, as a grantor, as an owner of the property, I can designate somebody as a grantee beneficiary, and that person, upon my passing and recordation of my death certificate, title automatically passes to the grantee. It passes subject to any deeds or any liens or anything that were on the property already. So these have become quite common, and once beneficiary deed is put of record, it stays there until it is actually revoked, and there's different documents for the revocation of it. So this one was done. And the thing about a beneficiary deed is that oftentimes a grandparent will have one and they pass and the beneficiary is a grandkid. First thing they want to do is sell the property. Grandma's passed and she left it to us and we want to get the property sold. So they call an agent, property's listed, we issue a title commitment, and we have a requirement on there that there's a 4-month waiting period after the recordation of the death certificate. So, and that's really surprising to people because they don't realize now they've got to wait 4 months before they can sell the property, before we can close on it. And I wanted to talk a little bit about that. And that's a state statute. And there's 2 reasons for this. So there's other people. So on a beneficiary deed, you're just giving it to maybe your favorite grandchild, but maybe the other grandchild thought they should get it too, or maybe grandma had promised it to them, and they feel they have an interest in the property. So a person having an interest described in subsection 2 of this, whose interest is not recorded in the records of the office of clerk and the recorder, shall record evidence or a notice of the interest in the property not later than 4 months after the death of the owner. So there's that 4-month window in there that allows somebody else that thinks they may have an interest in the property to come forward and claim that interest. That's one of the reasons we wait the 4 months. And if somebody doesn't record a notice or come forward, that forever bars them from claiming an interest in that property. So they only have 4 months to do that. The other reason is that the interest of the grantee beneficiary may be subject to any claim of the Department of Healthcare policy and financing for recovery of medical assistance. So if say grandma was in a nursing home and she had Medicaid and she was owed money, the state of Colorado has a right to come in and claim that and take and attach a lien to that property. So that's the 4-month waiting period. So we get asked a lot. Okay, well, I've got a buyer on this and we need to get this closed. And because we've had these now for 10 or 12 years and they've become pretty common, there are certain circumstances where we can actually close these. And I'm going to go over the requirements. So the first thing, if you've got a property, so say you've got a listing coming up, then you get your O&E and you see a beneficiary deed, that should be a flag that, okay, I've got a 4-month waiting period now. The 4 month starts from the date of death. So you'd have to ascertain when the owner of the property passed away. That starts the 4-month window. We can go to the Colorado Department of Healthcare Policy and Financing. And this document, and I can share this with you, or Jill can share it with you, talks about the recovery process in the state. And what we'll do is we can submit the name of the owner, and this has been redacted, but this is her date of birth. And thank you for contacting this office regarding Colorado Medicaid estate recovery. Ms. So-and-so was not found in the Medicaid system. As such, we will not present a claim for the recovery of benefits against her assets. So this lets us know that there aren't any bills, or the state's not going to be able to come back and try and claim an interest in this property. So that takes care of that portion. The other portion is, what about the other grandchildren or the other siblings or somebody that may have had an interest in that? If there is a will, if grandma had left a will, and we can get a copy of that, and I can look at that, or one of the other title officers here can look at that and determine that beneficiary under that deed, the grantee, was the only heir, then we can delete that 4-month requirement. Now, this isn't automatic, and we don't do it. We have to again ascertain the transaction and look at all the different documents. But we have been able to shorten that 4-month window. And I know other title companies are doing that as well. Part of it is the history of this. There really haven't been many claims. Hasn't been a court case in the Colorado courts that set some type of a precedent. So the fact that it's gone that far helps us be able to underwrite these. So if you get one, you have a beneficiary deed, and the commitment comes out and it's got a requirement for that 4-month window on there, let Jill know, let me know, and then we can work with you and the family to get the will and then something from Colorado Medicaid. So that can be, we're more open to doing that now than we used to be. Any questions on that?
There was a couple questions. Someone asked where they can get a copy of a beneficiary's deed. I'm assuming just a blank beneficiary's deed.
I don't think it is a standard form. I always recommend you consult an attorney on doing that. Anything with probate, it's not a form we can do. And if you're interested in doing that, I would look at this form again. Yeah, it's not really every form looks different. You know, I've seen them that are done handwritten. Always makes me a little nervous, but I always recommend getting a probate attorney and say, I'm interested in putting my property using a beneficiary deed to transfer that. This way, it does avoid probate, and that's the biggest issue of that. So typically, if she had done a beneficiary deed, grandma passes away, and she owned the property by herself, she has to go through probate. There has to be a personal representative appointed and a personal representative's deed to transfer the property.
There's another question, Terry, about can a contract be received before the 4th month, or is it best to not even list a home until the 4th month passes?
That's a good question. I think you can list it with the thought in mind, though, that there is going to be a 4-month waiting period. And I don't know I don't know if that makes a lot of sense to do that or to work. And maybe we can do some preliminary work for you to see if there is a possibility of eliminating that 4-month window.
Yeah, I think that's a good idea. Yeah. And we've certainly had it happen where we've been under contract and then, this issue comes up. Thankfully, the one I can think of most recently, the closing date wasn't for quite a ways out anyway.
Right.
So as long as you're closing, and would you say, Terry, too, it would make sense to be, if you were setting your closing date, maybe a week or so past that for exactly 4 months, because we need maybe a week or so of time for our title plant to catch up, all the recorded documents to catch up. So I don't think we'd want a closing date of the day of, the end of the 4th month, but maybe a week or so after that.
Right. And if you've been in some of my classes or other classes, we always talk about the gap period, which is just what Jill was talking about, between when we can see what was recorded at the clerk and recorder, and we can see it on our computer screen. So there's always that gap in there. So yeah. But if you have a listing and have a beneficiary deed involved, we're happy to take a look at that or do some preliminary work on that.
Brandy asks, would probate always take longer than 4 months, or would probate sometimes be faster?
It just kind of depends. In Colorado, if it's an individual, it's a pretty simple probate process. If there's not a lot of errors and you can go in, I've seen people do it themselves. But it's typically, it just depends, because there's a part of probate is you've got to advertise the property that the person had, not the property, but that the person was deceased, and you've got to advertise that in the local newspaper and give notice. There may be people out there they were owed money. So it's a lot cheaper. Beneficiary deed is a lot cheaper than a probate. A good probate attorney to go through that's going to take, it's going to cost to do that. So that's most of the reason people do it.
We've got a couple more questions that popped in related to other topics. Do you want to maybe kind of get through some more of your timeline, and then we'll see if
it's fine. I'm fine taking them. That was really all I had on beneficiary deeds. So
okay.
I'm fine just taking them. Yeah.
Okay. So Jerry's asking about, does a modest easement and encroachment agreement to improve a property line to the benefit of both properties cause lenders to consider the title to be compromised?
So a modest easement, was that the question?
Mm-hmm.
So like you've got an encroachment of a driveway or something onto the property. So I want to make sure I understand it.
So they kind of drafted some kind of little easement and just, I guess clarifying that benefit of both parties. Would a lender look at that and have concerns?
So that's a really good question, because if I own a piece of property, I have a good example of this. My wife and I bought a house once, and we had a half an acre, and we had a great, you back out of the driveway, and it had a nice retaining wall back there, and I put in a basketball hoop. The lot next to us was vacant. Well, they decided to build a house next door, and my basketball hoop and retaining wall is encroaching about 15 feet onto my neighbor's property. And he's trying to build this new house. So what he ended up doing was granting me an easement for that. And so that property now has an easement on that next door to allow for that. So that's an example of an encroachment where a lender comes in. So we did this easement agreement, and it's on his property, on my neighbor's property, and he had a deed of trust on that property, and he didn't have the lender consent to that or sign off on that. If a lender forecloses on that property, it's going to wipe out that easement. So if you think about lenders and deeds of trust, and I'm actually going to talk a little bit about foreclosures today. When a lender forecloses a deed of trust, any type of a deed of trust, if it's a first deed of trust, anything that was recorded subsequent to that, whether it's a second deed of trust, a HELOC, an easement, or other type of document that the lender didn't approve or agree to, they wipe that out. So you could go through all the work and have this easement in place, and the lender forecloses and they didn't consent to that easement, they wipe it out. So we work with a lot of lenders where we've issued a loan policy, and so the borrower will come to them and say, hey, well, now the city, even say the city's going to take a portion of the land for an easement, new fire. I actually saw one this week for a new fire hydrant, and he wanted us to do title work on that. So either the lender has to partially release that easement portion where that fire hydrant is going to be, or they have to subordinate to that easement, because if they don't approve that and agree to it, and there's a foreclosure, they'll wipe that out. So typically on city transactions like this fire hydrant, they're going to require the lender agree to do that. And you'll see lots of times on the form, they'll have a place where the lender can sign off and approve it. So I don't know if that helps or not, but yeah, lenders do consider that can be an issue. If it wasn't properly done, it has to be properly done. Everybody has to agree to it. And again, I always go back, we can't prepare an easement. We see these types of encroachments come up on an ILC, fences, retaining walls. We can't prepare that. We always recommend that you go to a good attorney that understands that, because there's more than just granting an easement. Who's going to maintain it? Who's going to take care of the yard? In my case, I was going to maintain the asphalt and the basketball hoop. So does that help?
That's a great example. Yep. Good example, Terry. You've got lots of stories that you can after 47 years.
Both personal and work related. I do have a lot of issues. Not a lot. Well, I do have a lot of issues too.
A lot of issues.
A lot of stories.
That's another webinar.
Yes.
There was another question from Ray, and I think we could do a whole session on this, which I think would be really interesting. So Ray's interested in hearing examples of title insurance claims that have been paid in the last year or so.
Well, I have several that I've been working on. We just got through one, which was an easement. So we have and talking about easements. We have one where it involved an easement. Very convoluted and kind of involved, but the seller was supposed to grant an easement to a buyer next door. It didn't happen, even though everybody had agreed to it in the counter proposal. And come to find out, the neighbors hated each other, and that got kind of ugly. In fact, that ended up in mediation. That was the first time I was ever in a mediation case over that. So easements, we have a lot of issues with fences and encroachments and resultant claims. That's why oftentimes I can talk about that too. Another whole seminar on surveys, we do have some classes on surveys. Mechanics liens can result in claims. So remember, a mechanics lien, if you're buying a new house, new construction, or if you've listed a house where it's just been remodeled, say it's a fix and flip, and not all the contractors and suppliers have been paid. They have, after their last day of working, they have 4 months to file a mechanics lien. And we will always get an affidavit from the seller stating that everything's been paid for. There aren't any unpaid mechanics liens, but that doesn't always happen. So the mechanics liens, we'll get involved, try and resolve that. So easements, mechanics liens, we've had fraud cases lately. And I'm actually going to talk a little bit about fraud. Title insurance protects against fraud, forged signatures. And I had a deal yesterday where we were alerted to a forged signature, and we hadn't closed it yet, but it was a case where it was some bad people had actually created a quitclaim deed. And this was an absentee owner, and the absentee owners, that's a big issue these days. The absentee owner, and they had created and forged a quitclaim deed and conveyed it to somebody that was going to fix it, flip it. And one of the things that was kind of interesting is there was such a push to close this thing. It's had to close, and we couldn't. It has to close. So we were alerted to it that it was a potential forgery. What had happened is whenever we're going to do a transaction, we reach out to the seller because we need to get the seller's permission to contact his lender to obtain a payoff from his lender. The lender's not going to give it to us without the seller's authority. And so we reached out to him and he got this, and he contacted his niece who worked for another title company and said, hey, I just got this request for payoff from Heritage Title. I'm not selling my property. And fortunately, this other title company alerted us to that. And I found out that now a police report has been filed, but that was just yesterday. So that's a big issue. We're constantly on the lookout for fraud, especially absentee owners. And I'm sure you've all heard of the issues with that. If we have a lot of internal steps. If we have an absentee owner, somebody that is out of town, we actually reach out to them and contact them and make sure you selling this house. So we've got a lot of steps in place and processes in place to hopefully avoid that. So fraudulent documents, I had a deal a couple months ago this is on the Western Slope, and it was a cemetery, and it was a family-owned cemetery. They're selling it for about $3 million. And they had hired a local person, a lady and her 2 kids, to maintain the cemetery. And they mowed the lawn and cleaned it up. And she was owed about $35,000. So she filed a mechanics lien, 3 mechanics liens on the property, and said, okay, well, this guy hasn't paid me. So our escrow officer, so they show up on the title commitment because they were recorded mechanics liens. Our escrow officer contacted her, had her come in the office, and we went ahead and because we were going to collect the money from the seller at closing and pay her the $35,000. So we went ahead and prepared 3 mechanics lien releases for her to sign ahead of time, just to help, the transaction along. Then the day of closing, we would get a check from the seller, give her the check, and we already had the mechanics lien releases. So the morning of closing, the seller emailed us and goes, hey, I just recorded 3 mechanic lien releases, so this should be cleared up today. So he or somebody, and they were signed by an attorney out of Dallas, he had forged these 3 mechanics lien releases, not knowing we already had 3 signed by the real mechanics lien claimant, and went ahead and went down and recorded them at the clerk and recorder. And so it was a clear case of fraud, so we wouldn't have paid $35,000, luckily. And so we contacted the real mechanics lien claimant. She was, I don't have an attorney in Texas. I don't know anybody in Texas. And so she was able, this is a small mountain community on the Western Slope. She was able to go to the clerk and recorder and have those documents pulled. And then they called the county sheriff on that one. So it's just constant. We have to look out for it all the time. So say, for example, we didn't realize that would be a potential claim. So forged, title insurance protects against forging, fraud and forgery. So if we had closed that deal yesterday with that forged signature, the buyer would have a potential claim against us. It's constant.
Those are some great examples. Yeah, it's constant. I think it'd be interesting to maybe do one of these with a claims attorney who, if they'd be willing to do that and talk about all the different things that come up. I think there's a perception that title companies never have to pay on claims, and it's simply not true.
It's simply not, yeah. And our company, we're part of Fidelity National Financial. We literally have billions of dollars in claim reserves. So it's something we actually we do. We're governed by the Colorado Division of Insurance. We're just like any other insurance company. You can file a claim if you're a buyer and you have an owner's policy, and you've got had one this week where a guy had bought a house and felt that his neighbor's fence was encroaching. So we can kind of walk them through the process of a claim. But yes, we do that. So
Joan had asked about the commercials that she's seen on title theft. They're offering protection from this happening. Does this actually happen? She's had clients ask if this is something that they need to be concerned about and consider.
Yes, title lock. Yeah, I get asked that a lot. So you see the commercials, you see Bill Riley and everybody, talking about it. And it does happen, but it's pretty rare. So the premise is that you're an absentee owner, and they're gonna find out that you don't live there, and they either go into the assessor's records, like Denver County assessor's records, looking for homes that are unoccupied, or absentee owners, which is easy to do because you're going to see that an address in Denver, but the owner lives in Florida or California. And then they can do some research and find out that it's free and clear. It often happens on free and clear homes. And so they'll forge a deed and record it, thereby transferring the property to themselves, the bad guys. And in the meantime, they go out and they go to 3 different lenders and they borrow $100,000 3 times, and they take the money. And then all of a sudden, these lenders are contacting you saying, well, you owe us this money. So it's kind of rare. And I actually did a lot of research on this because I was really curious, because I get asked it so much. Where do they get their research? Because they have to get their data from somewhere. So their premise is that somebody does a deed on your house, you're going to get notified about that. And there's several assessors' offices now. I know there's several in Colorado that are sending out notices to property owners if there's a kind of a random deed. So when we're doing a title search, we always look for what's called a full value deed, which is a warranty deed, special warranty deed, personal representative's deed, where you've got a dock fee, was insured by another title company. So if we see something like that, we see a warranty deed insured by us or a competitor, full value, well done. You can look at it and tell it was done professionally. We're pretty comfortable that that's a good deed and we can rely on that. On the other hand, if we're doing a chain of title and we see a handwritten quitclaim deed that just kind of comes out of nowhere, we question that. We're gonna look at that. So to us, that's a red flag. If it's not a full value deed, if there wasn't a title insurance company involved, and we can see where other title companies are involved. We share title plans, we share information with each other, so we can see that's a red flag to us. So we can ask questions about that. Oftentimes they're not done properly. A lot of times these bad guys are from out of the country. It's not notarized properly. I hold title as Terry N. Williams, and maybe they just did a quitclaim deed from Terry Williams. That's a red flag. So, because what happens is that once that deed's done, an assessor is going to look at that too. But if they take that to a lender and they're going to try and do even a HELOC or some type of a loan, that lender is going to want title insurance. And so that lender is going to contact us and say, okay, I've got somebody here, I have free and clear property, which is always kind of a red flag to us anyway, free and clear property these days. If we see a property that's free and clear and there wasn't a recent deed of trust, like a refinance, that's kind of a red flag. There's not a lot of free and clear property out there. So we would start asking questions about that. And so the odds of them actually getting a loan on that is pretty slim, at least something insured by a title company. But again, I was really curious about this. So I signed up for 2 months. And actually, I was actually pretty impressed with the data they had. But you can also get that data from your local assessor's office. You can run an O&E. And I don't know what the cost was. I canceled it after a month or two because I wanted to try it out. So if you look at their website and you get down to the fine print, it says in the very rare example that your property is actually stolen, as long as you have an account with us, we'll help defend you. So that kind of opened my eyes when they even themselves admitted that it was a very rare event. It does happen. I always recommend, maybe just jumping on the assessor site. We could all, could show you how to do that. Checking your property, especially if it's free and clear. Maybe you live out of state. Checking that, we can we can do an O&E for you. But again, I heard that more and more assessors, because of the fraud, are alerting owners the same way. So I don't want to say it's a scam, because I don't think it's a scam, because they really do have good data, but I don't know if it's a wise investment if you're kind of doing your homework and watching your own property.
I actually put together an email blast, and I think I never actually sent it out. So I think that would be a good follow-up to this, but it's exactly what Terry's talking about. I've got links to all the counties in Colorado that offer the service where you can sign up, and if there's any change to the ownership, they notify you immediately. So it's basically a free service offered by the counties that do the same thing. So I'll make sure you all have that.
Yeah. So that's a great question. I get asked that a lot.
Yeah, very good question. Okie wants to know why you never age. It's because he's Benjamin
It's
Button.
the light. I'm a special camera. Thank you, Okie.
Okay, that's all the questions for now, so we
Okay.
can move on to your next topic.
Okay, I want to talk a little bit about geographic targeting orders, GTOs. Does anybody, well, I can't really get a share of hands, but are you familiar with the geographic targeting orders? This just came out this year. So this came out in April of this year. So the Financial Crimes Enforcement Network, FinCEN, mission is to safeguard the financial system from illicit use and combat money laundering. So this is all about money laundering. So for those of you that have seen Ozarks, think about Ozarks and the money laundering involved in that. So in April of this year, Colorado was finally included in this. When FinCEN first did this, and they first started with the money laundering issue, it started on both California, West Coast, and East Coast, and it's finally kind of moved our way now into Colorado. So these counties, Adams, Arapahoe, Clear Creek, Denver, Douglas, Eagle, Albert, El Paso, Fremont, Jefferson, Mesa, Pitkin, and Summit, and I've got a map here, are all subject now to the geographical targeting order. And if you look at the map, you can see that it's pretty much I-25 corridor, I-70 corridor. A lot of that is because of the drug trafficking that comes up here, and even human trafficking, from what I understand, in and out of the state. Unfortunately, I-25 and I-70 are pretty substantial pipelines. So they want to know, when we're doing cash transactions, who is doing that. So if for your own information, or if you've got sellers or buyers, so all offices, and this is an internal memo. So sale of residential property, 1 to 4 family, including condominiums, co-ops. So sales completed between April 25th, 2023 through October 1st, 2023, and then subsequent to that. So it started in April. So the sales price is at least $50,000. I'm sorry, that's in Baltimore. So in Colorado, sales price is at least $300,000 or more in all geographic locations. So if you're buying a piece of property for $300,000 cash, over $300,000, and the buyer is a legal business entity, LLC, corporation, partnership, except for a reverse exchange, a business whose common stock or equity interests are listed on a securities exchange, a self-regulated organization registered with the SEC, you make that money without a bank loan, you're paying cash for it. We're going to ask, we have a form that you have to fill out, and we'll help you fill that out. And we need to, once that form is filled out, and we want to know the authorized signer, the purchaser entity, any individual who ultimately has 25% or more beneficial ownership interest in the buying entity. We have to provide, the buyer has to provide social security numbers, employee identification numbers, and we have to submit that to our home office, and they run that through FinCEN, and we get a clear to close on that. And where this gets kind of critical is that, say you've got investors doing fix and flips, and he assigns that contract to somebody, to another LLC who's going to pay cash, and they want to close tomorrow, which is not that unusual. We have to tap the brakes and go through this and get that information. Now, if they are doing, actually, if they're doing a loan, it doesn't apply, because all the banks have their own way to vet borrowers and avoid the money laundering. So it's just cash deals, LLCs. It doesn't include a trust. So if you're buying fix and flips in a trust, it doesn't apply to you. It's just LLCs. So this has been, actually, it's gone really well. We have a really good process in place. We've had several of these, and we close on them regularly. And it just is going to take an additional 48 hours. And I think that's the most important thing you need to know. So any questions on that? So that's
Not so far.
Okay. Again, it's a pretty seamless process, but just so you're not surprised if you get a call from an escrow officer asking about that. Okay, I'm going to talk a little bit about foreclosures. And I'm just going to touch on it briefly. We're seeing a foreclosure market again. I can't tell you how many I've been through and seen over the years. It's just part of the process. It's part of the ebb and flow and the ups and downs of the real estate business. So if you have not, we have this wonderful foreclosure class that Dean Rival puts on. And Dean, if you get an opportunity to take this foreclosure class, it's a 2-hour, maybe 3-hour CE class. It's really good. Dean goes into great detail on it. But the premise is that we're starting to see a lot more of those. And, they're advertised by the public trustee. Colorado is really unusual because we're the only state with a public trustee. Most states, for those of you that have come from California, Arizona, different places, they have a private trustee where title companies are normally private trustees. So they're the ones that conduct the actual foreclosure. Title companies in California have huge TGA, trust guarantee offices, and that's all they do is they do foreclosures. But in Colorado, it's done by the public trustee, which is an appointed official. Each county has their own public trustee. And this is a sample of a deed of trust. And, the first process of it is once somebody is late on their payments, they file a notice of election demand. And I'm sure you probably get that list from Jill on a weekly basis. And that's
if you're not, let me know and I can sign you up for it. Yeah. In fact, I'll put a link in the chat. Give me a second. If you want to sign up to receive that, this is a quick, easy way to do that.
Because that's the first notice that there's a foreclosure in place, is a notice of election demand. And then that there's going to be, and then also we have another list, which is the sale list, which is the list actually of the property that's going to be sold by the public trustee on Wednesdays. So, and actually, I think in this part of this handout, I thought we had a list of the counties, maybe of when their sale dates were, but so the list comes out on Tuesday. And so that's typically a big O&E day for us because if an investor is going to go down to the county and bid, although I think it's all done online now, I think the days are over thanks to COVID, where you actually went down to the courthouse, to the public trustee's office and bid. I think it's all done online. But if you're buying a foreclosure, you're going to want to get a good O&E on that because, first of all, you want to make sure you're buying a first deed of trust. So if we talk a little bit and think about foreclosures, first deed of trust is going to foreclose. It's going to wipe out everything behind that. Second deeds of trust, third deeds of trust, judgments, mechanics, liens. If you accidentally buy a second deed of trust, which I've seen happen because people really didn't do their due diligence, and you buy a second deed of trust, you think you're getting a really good deal, but you take that property ultimately subject still to the first deed of trust because that's in a priority position. So for lenders, it's always about priority. Where are they at? What's their priority? So we encourage a good O&E on that. And then actually it's important you do your own homework too. So if sometimes when you see property in foreclosure, they're going to have a lot of judgments as well. And those judgments are wiped out as long as they're properly notified. And that's part of what we've got a product called a foreclosure guarantee. So one of the first steps in a foreclosure is the attorney will notify us and order a foreclosure guarantee. So we do a product that lists everybody, shows the deed of trust that's being foreclosed, and everybody that has an interest in that property after that. Second deed of trust, third deed of trust, judgment creditors, IRS liens. This is a different story. And because they have to be notified, because they have redemption rights where they can come in, redeem that, and try and buy that first and take the property. If they're not notified, they have a right to set aside the foreclosure. But if they are notified, they also have a right to redeem, and there's certain redemption periods. But if you're buying a foreclosure, when you're looking at the property, you're at the public trustee's office on their website, look at the O&E and look at who was notified. If you see some notifications over here for Acme Credit Company or GMAC Credit for a car loan, and that's not on the O&E, there's a problem there. It's possible that they weren't notified. So you want to check that. And Jill's got it. We have a wonderful product that Jill's going to pull up. What I have a full-size copy here you can't read, but Jill's got it. So in Colorado, the foreclosures, it's a very, very precise timeline about what can happen and when it can happen. And this really spells it out. Jill's going to show this. Yeah, this is a great product.
You seeing that now?
I am, yeah.
Okay.
So scroll down a little bit. So you look at the overall the cure period. So you look at the over on the left that's the cure period. The buyer, the debtor has to cure the property. Then you have the redemption period, and then it talks, 110 to 125 days, 45 to 60 days, no less than 45 days. All the different hearings, when you have to submit a bid, when the borrower could cure the default. So if you're going to work in foreclosures, this is a really handy tool. And then it talks about all the, once everything is done, and all the subsequent lieners, they have 5 additional business days to redeem at the bottom. And then finally, the confirmation deed upon expiration of all the redemption periods. If everybody's been notified, you are issued a confirmation deed and you own the property, free and clear of all those junior liens. The only exception to that is the IRS. They always are going to get paid. And if there's an IRS lien on it, so the IRS has 125 days to come in and redeem. And because it's Colorado, because this is a Colorado law, Colorado statute, the foreclosure, they don't recognize the IRS. So if you have an IRS lien on your property and you go ahead and buy it, the IRS has up to 125 days to come in and redeem. Now it's really unusual. I've seen maybe only 1 or 2 where the IRS actually does come in and redeem. But if you bought something with an IRS lien, there's going to be that risk. So again, this is a really good handout. If you're interested in learning more about it, be more than happy to help you with that. Again, the class the dean does is really well done. And then, as Jill mentioned earlier, we're starting to see some short sales again. Short sales are quite common years ago, and unfortunately, they're coming back because they can be kind of difficult to work with. But we can close them. I've had some people ask if we can close short sales, and we absolutely can. Anything else on foreclosures? I know that's just kind of brief. I just wanted to talk about it. I did about a 2-hour class on foreclosures a while back, so we can talk about that too. A lot.
Yeah. Let's see. Joan is asking, this process has not had any changes to the dates timeline for the past 15 years, has it? How long has this been the timeline?
I think it's been about 15 years now. It was different back in the day. It was different. So this is the latest one. Yeah. So it has not changed. And I don't think there's anything on the horizon in the legislature to change it.
Good question.
Mm-hmm.
Okay, that's it for now.
Okay. I wanted to talk a little bit about, I always talk about this, power of attorneys. We have a lot of issues with power of attorneys. And if you've got a transaction, seller or buyer, and there's going to be a power of attorney involved, we would prefer to use our form. If you've got a seller going to be in Mexico, out of the country when the closing is going to happen, we can prepare that power of attorney for you. To us, power of attorneys are somewhat of a red flag because it's unusual. So our question is, why is there a power of attorney involved in this transaction? Are the parties out of the country, incapacitated, something like that? So we've had closings where we sit down at the table and somebody walks in with a power of attorney that hasn't been pre-approved by us. And I see these all the time. I saw one this morning actually that was not that great. And it said it only takes into effect when the person is incapacitated. Well, this person wasn't incapacitated, but they didn't realize in that form, they appointed somebody, their agent, to be a power of attorney, that the power of attorney doesn't work until they're incapacitated. And we have to have letters from 2 different doctors stating that they're incapacitated. So I didn't hear back on that one. There's not a day goes by that we don't look at power of attorneys. And it's unfortunate when some of them, we'll see some that are military power of attorneys that give the spouse that's here the right to do everything except sell the home. I've seen somewhere they say they can sell the home for only $300,000, but now they've got a contract for $250, or the other way, 325. So power of attorneys are a big deal. Damien and I talk about a lot about this, and if he was on, I know what he would say. Make sure you get your power of attorneys looked at. And again, we have very specific forms for buyers, power of attorneys for sellers, and refinances. So let us know if you've got a power of attorney. We can look at that in advance for you, and we can prepare them too, which we would prefer to do. Okay. So I had this thing. These are always kind of easy to do because these are examples I deal with. I dealt with this one yesterday, which is kind of interesting. So if this has to do with a buyer, if you've got a buyer and they're buying a piece of real estate and they're going to buy a home, and they have a purchase money mortgage, which is a new deed of trust. And if they have a judgment or an IRS lien against them, we can still close that. I'll talk a little bit about that. This is not against the seller, because once that judgment is recorded against the seller, it attaches to the property, it has to be dealt with. This is against the buyer. And you'd be surprised that, the number of these that we see where the buyer's got mainly an IRS lien. So this is an IRS notice. So it works for this one specifically for federal tax liens, but it also works for judgments. And I've got a Word document here. This is something I put together because I have to explain this so much. Judgment, IRS liens, subordinate to purchase money, deeds of trust. So going back to what I was just talking about deeds of trust being in a priority position, because if they foreclose, they want to wipe out anything behind it. If anything is in front of that deed of trust, they can't foreclose it. So you've got a buyer who's coming into title, and that judgment, he's got a judgment against him or an IRS lien. As soon as he closes, that's going to attach to the property. Okay. So if you've got a property and say you own several properties in Denver and you have a judgment recorded against you, that judgment automatically attaches to that property and will stay there until it's released and satisfied by the court. Same with an IRS lien. If you have an IRS lien, and they record it, it's going to attach to everything you own. The theory with this is if I'm a buyer and I've got a judgment and an IRS lien against me, I'm going to buy a piece of real estate. The lender wants that subsequent to their deed of trust, behind their deed of trust. So if they foreclose, they can foreclose that out. So the theory is that if we have a sale and I'm a buyer and I have a judgment against me, Jill's the seller, she's going to sign a warranty deed to me. And then I'm going to sign a deed of trust to the new lender. So if you think about that, those are two concurrent recordings, two concurrent reception numbers, record at the same time. There isn't any way for a judgment or an IRS lien to attach in between those documents prior to the deed of trust, which means that as soon as I record my warranty deed and the deed of trust, then that judgment and tax lien attaches to the property, and I have to deal with that if I go to sell it. But it can affect the lender. And it's always, not unfortunately, but it's always about the lender, what the lender wants to do. So we can close those. And what we'll do is so this is about, again, when you're talking about loan policies and documents that are subsequent to the lender, there's a section in a loan policy, which is Schedule B, Part 2. And that's a part of the policy that shows subordinate matters to the deed of trust. So what we'll do for a lender is we'll show the judgment under Schedule B, Part 2, and we're saying, okay, well, your deed of trust is in first position, and this judgment or this tax lien is subordinate to that. So if you foreclose, you're still going to be in a priority position. And then what we do is we take exception to it on the owner's policy. You all remember exceptions on an owner's policy or exceptions on a title policy are items that we are going to protect you against. Those are items that show people have other interest in the property, easements, and so on. So on your owner's policy, if you have a judgment, we're going to list those as an exception on your owner's policy. And so in the title industry, sorry, somebody just distracted me. Kind of like that squirrel mentality sometimes. If you created, assumed, or suffered something under a title policy, we don't cover you for that. So say you get a title policy and a year later you get a judgment against that. That's suffered, created, assumed. That's not something we're going to cover you against. But this judgment in this case, you already had it, and now it attaches to your property, and we take exception to it. Now, you're going to have to deal with it when you sell because it's attached to the property. So that's kind of an interesting theory. I always find it kind of interesting. A lot of people don't understand that, but we can, if you've got a buyer, we can insure that transaction, insure their lender. It's always about the lender again. So any questions on that?
Yeah, we had a couple questions pop in. So will an O&E show any recording of forbearance that a seller may have filed for during COVID?
It should show that. Because it's considered an encumbrance. So yes, we should show that on an O&E. And that's always a surprise to some sellers. They don't remember that part about having to pay it back.
Yeah. I know those payoffs can sometimes be tricky too. I know that we've had that come up. So if they've got a forbearance, it'll be a little bit of a tricky process.
Yes.
Oki asks, why would a lender lend on a buyer who has a judgment or owes the IRS? Would that count against his credit?
It does, but oftentimes with an IRS lien, if it's a big IRS lien, they have a payment plan set up with the IRS. If you think about it, not like a credit card, but you have a lot of borrowers that have credit card debt and other debt. And if they've got a payment plan with the IRS and otherwise their credit's good, maybe it was a failed business or something, they'll still loan money to them. This judgment I had yesterday was like a $2,900 judgment, but I think the lender felt he was credit worthy enough to go ahead and make the loan. So, and oftentimes we have common names. You've probably all seen that on your title commitments. I live in El Paso County, and there's another Terry Williams down there, and he's got a lot of problems and judgments. And every time, something shows up, and it's not me, but there's another Terry Williams. It's a pretty common name. So you'll see that sometimes. So we just need to make sure if it's a seller that's not that person, whether it's a judgment, IRS lien. IRS liens are easy because we can check the social security numbers, the last 4 digits of the social security. Judgments are a little trickier, but yeah.
Great. Anything else you wanted to share today?
No, I was going to talk about fraud. And I think I did that. We're just very cautious of it. We used to have this really nice hold music. And now all we do is the hold messages is we will never change our wire instructions. And so we won't ever change our wire instructions. We don't send them email. Email. We've had occasions where it's a horrible thing when a closer will be sitting at the table and so the closer said, "Do you have your funds?" Well, we wired them 2 days ago to you. And what happens is that their email is intercepted. They spoof our email from a closer, and it's amazing how they can do that and how realistic it looks. And you can always kind of tell sometimes because the punctuation wasn't great. But now what's scary is with AI, they're having AI write these spoof emails, and it looks like it's written by us, changing wiring instructions, and then that sends it to a bad guy's bank. Again, we will never change our wire instructions. We only give them out verbally or to a known number. We've had instances where the money has been sent, and we have relationships with the FBI, all the major lenders. And as long as the money hasn't gone offshore, we can typically recover it, or a good chunk of it. That's a horrible thing for a buyer to sit down and realize that they just wired $400,000 to a fraudster. So that's a big issue right now.
It's a big deal. Oki, do you have a question? I saw you raised your hand. I've never done this, but I'm going to try the allow to talk. So I'm going to allow you to talk. If you meant to do that. I know sometimes it's easy to click on something. Okay, I'm going to guess that maybe that wasn't intentional. Okay.
Yeah, I had a deal recently. Oh
no,
I was going to tell you that I do a lot of estates, and this year I had 2 estates. One, the heir just didn't bother to make payments on the house, and it went into foreclosure. I caught it about 30 days before we went to close on the property, and was able to keep it out of foreclosure. And then the next one was the same thing, that people don't realize that they're supposed to make payments, especially if there's a loan on it.
Mhm. Yeah, if you're the beneficiary under a grantee under beneficiary's deed that grandma left you, and there's still grandma had a loan on the house, the payment still has to be made because it doesn't wipe that out. That's a great case. That's a great example.
Hey, did anybody else have any questions or anything you want us to touch on today? We've got a few more minutes left here before the end of the hour, and we're happy to answer any questions at all that you might have.
If you have any questions, even on a deal you've got with another title company, you have some questions on that, happy to help you with that. If you've got a buyer who looks at the exceptions and they get a little freaked out, some of our mineral exceptions here in Colorado, people on the East Coast aren't used to seeing oil and gas leases on their property. I'm more than happy to have a conversation with them, try and explain it. Not an attorney, so I can't give them any legal advice, but I can tell them how it impacts the property and why we're showing it as an exception to title. ILCs, we require ILCs, and I know we get a lot of questions about that. And that has to do mainly with where the property is. If you're up in Jefferson County and it's a meets and bounds property that's been there a long time, and we look like there could be fence encroachments. If you're in Colorado Springs and you're, in El Paso County, you're in Manitou Springs, or you're doing a mining claim in Boulder County or something like that, we're probably going to require an ILC because the buyers are always going to want owner's extended coverage. And in order for us to do that, some properties we're going to need an ILC. Google Earth is one of my best friends these days because I can look at property from a street view, aerial view, and sometimes determine that we really don't need an ILC on that. But we do require them at times in order to give the owners extended coverage. That's the reason we do it.
Yeah, that's a really good point. I mean, and just to remind everyone that just because something shows up on a commitment doesn't mean it has to stay on there. So know that you can always reach out to that title company, ask the closer if you can talk to one of the title officers or an underwriter. You can always ask, and they're always happy to kind of dive into it and look at it a little closer. So yeah,
there are insureds, the owner's going to be our insureds. We're issuing them an insurance policy. So we want them to understand it and be comfortable with it. Going back to the absentee owner issue, I had a transaction a couple of weeks ago where we weren't really sure. We were a little suspicious of the seller for whatever reason. I don't know all the details, but we did our due diligence and we contacted them and we asked the agents involved, did you actually see them? Did you actually see their driver's licenses? And come to find out that it was the right people selling, but we freaked out the buyer because we did so much inquiring, the buyer was really concerned. And the buyer said, well, we want assurances from you now that if I buy this, because you're concerned about it, that it's going to be good. And so I talked to their attorney about the title insurance policy. And once we issue that policy, it's going to protect against forgery and fraud, and made them feel comfortable with that. But it should be something that's in the forefront of everybody's minds these days. We just want to be safe, and we always want to make sure we do it right. We're a conservative title company. We do things right, and we want to put out a good product and make sure our insureds are covered. So,
Priscilla asked a great question. A property title is changed to an LLC after purchase. Does it affect title insurance?
That's a great question. So we issued the ALTA, American Land Title Association Owners Policy version in 2006. And if the policy was issued after 2006, it contains provisions in there that if you put your property in an LLC, a trust, you get married and deed it to your new spouse, you go through an estate, then you are automatically covered as an additional insured under that policy. We also, if some people are still not comfortable with that, we issue an endorsement. It's $250 called an additional insured endorsement. So once you record the deed to your LLC, typically if people are working with an attorney and the attorney's handling that transaction for them, they're going to want the endorsement to the policy. So you always hang on to your owner's policy because that's your title policy, because we can endorse it down the road if you have a claim. We're we ultimately acquired, for those of you that have been around a long time ago, the old Transamerica files, Transamerica. And I got a claim request last year from a lady in Longmont who had a 1969 Transamerica owner's policy. And she had bought this when there wasn't anything going on in Longmont. And now all this growth around her, and she was going to split her property into a couple different parcels, and she needed something to give to the county to show that she owned it. And she still had this policy, and she had the original policy. So I was able to give her an endorsement for like $57 that showed her that she could take to the county, showed that she still owned that property. So, but if it's that old, we don't have, our records don't go back that far. So it's always important to keep those. We email them to you now, but a lot of people still hang on. It's important to hang on to them. I still have the one, because I'm a geek. I still have the one from my parents' house that they bought from Stewart Title in Greeley in 1969. So
Interesting.
Mhm.
Very good. All right. Well, if you have any questions, you guys, that pop up later on, or you have something that comes up on a transaction, reach out. I'm happy to reach out to me or reach out to your Heritage Title sales rep. We're happy to be a conduit to Terry. He is right at our fingertips, and as you can see, is just a wealth of knowledge, and he's just so great at figuring out solutions to things. I get calls all the time from brokers who have something going on with title on a property that they're getting ready to list, or it is listed, or it's at another title company and there's a big issue. Call us. We're always happy to take a look at it. I'll loop Terry in, and we will roll up our sleeves and figure out some way to get it figured out for you 99% of the time. So
If it's
just
something we can do,
happy to do that.
We can get it figured out. So
Yes, for sure. Oh, it looks like we got a couple more questions. Oh, just thank yous. Thank you so much. Yeah. Thanks
thank you
everybody
all.
for joining. We are so thankful that you spent some time with us this afternoon, and please reach out. We're happy to help anytime.
Mhm.
Thank you, Terry.
Okay, thanks everybody.
All right. We'll see everybody.
Bye now.
Not next month, but keep an eye out for February. Will be our next industry update. We'll roll out the whole year of industry updates here in the next month or so.
See you
Right.
next year.
Sounds good. See you next year.
Thank you.